Hello, today we have with us Maria de Lancastre Valente, People and Culture Director of SRS Legal and also partner of the same law firm, that will talk about the recent changes to the labor law. One of the matters that was highly amended is the information duty. It seems to me that the burden over companies increased a lot, and the bureaucracy also.
Well, I think you see a lot of increase in bureaucracy across the whole spectrum of the reform. I think this is one of the, a very evident example of that. So we know that under Portuguese employment law, at least a permanent employment contract does not require the written form. So companies have to pay attention to, ticking the box in relation to the list of information that has to go into those employment contract. I think there are 11 pieces of information that were added in. So in terms of procedure and of preparation, that's something that companies should look out for.
And they also should look out to the deadlines because the
deadlines decreased.
Yeah.
So companies formerly had, or employers formerly had, a period of 60 days to communicate certain information to employees, and that has now been reduced to 7 or 30 days, depending on the type of information that's being conveyed. So first recommendation would be to look out for those changes, and the second would be to make sure that those changes are communicated promptly to avoid sanctions, administrative sanctions.
Maria, about remote work, that was a regime with little use until the pandemic, and now is constantly at the spotlight. The lawmaker decided to amend this regime in order to clarify some matters. Can you talk about what these amendments represent?
So it's very interesting because, as you say, and as you point out rightly, the remote work regime exploded during the pandemic. And what's interesting is that it is in our labour code since the beginning, so since 2003. And only really did multinationals really pay attention to it. So certainly for the Portuguese universe of companies, it wasn't a regime that sparked a lot of interest. Obviously, the pandemic shook the regime up a lot, and obviously the resort to remote work was huge. And one of the aspects that caused a lot of headaches, I think for everybody, for both employees, employers, lawyers, was the issue behind additional expenses, what additional expenses represented, what the concept of additional expense meant, and how it was treated, even from a tax perspective. And what this regime, or rather this change to the law now clarifies, is that these expenses have to be, the amount, the compensation for these expenses has to be stipulated specifically in the employment contract or in an applicable collective bargaining agreement. So that's the first issue. The second change relates to the treatment of this compensation and of these additional expenses. So the law now clarifies that these expenses and that this compensation is not deemed employee income, and it's a deductible cost. And so obviously that clarifies the issue regarding the tax treatment for employees. The only issue that we still have is that the law introduces a cap to that exemption, and we do not yet know what that cap is. So we're still waiting to understand what the exemption limit is to treat that as a deductible cost and exempt income for employees.
Right. That is very interesting because my perception is that when remote work stopped being mandatory after the pandemic, it was somehow back in the drawer, right? And do you think these amendments will help remote work to be a more useful tool for companies?
I don't necessarily agree with you that that it was put back in the drawer. I think what companies are doing is they're trying to balance out the use of remote work. So I don't think we've reached a healthy balance. I think companies are still operating as our employees under sort of a trial and error regime. The challenge here is to balance productivity with cost and a preservation of work culture and purpose, which are concepts that traditionally employers didn't have to worry about, and now they do. And so I think that also ties in nicely with the last point that I wanted to talk about, because this reform did introduce a number of changes to parental rights, be it in widening the scope of absences and also introducing sort of a broader balance between rights shared by mothers and fathers. And so the main one is the extension of the father's exclusive parental leave from up to 28 days, so a full month practically. So I think that is one of the positive changes that this reform has brought about.
So Maria, what should a foreign investor look out for?
I think they should look out for the things that they should already be looking out for, and that they should have been already looking out for prior to the reform. So I would give three pieces of advice. The first one is don't improvise, always prepare. So because we are a regulated jurisdiction when it comes to employment law, room for improvisation and for creativity is very limited. So when you're choosing to invest in Portugal and to hire and to manage a workforce in Portugal, you should do your homework and make sure that you do prepare with enough time, and ask specific questions around how you can hire, what alternative means of hire you can resort to, what you should be looking out for if you're thinking of changing certain terms and conditions, and in what terms you can dismiss, because the repercussions may be significant, both in terms of cost and legal exposure. So that's my first tip. The second tip would be, don't underestimate the procedure. So again, because this is you're operating within a regulated legal environment, there is a specific value to procedure. And I think one of the down points of this reform is that there is more bureaucracy. But I think that provided you are able to navigate and you're able to grasp the main stages of the life cycle of an employment contract and of employment relations, and provided you tick the right boxes in relation to the observance of specific procedures, you will be fine. So I think that's my second tip. And the third one would be a timeline. So immediate changes, 99% of the times, will bear a significant legal exposure and risk for a company. So when you're thinking about introducing changes, and if some of those changes are radical, make sure that you prepare in advance, that you follow the procedure, and that when you're planning, you do so with time. And finally, a last one would be to factor in cost. So in our jurisdiction, there are costs associated to certain actions and to certain omissions. So make sure that when you are thinking about hiring, that you do marry the planning, with the procedure, with the timeline, and with the cost. And I think if you get that balance right, you'll be fine.
You'll be fine.
Yeah.
You'll be fine. Maria, it was lovely to have you here.
Thank you very much.
Thank you very much for your insights. They were super valuable. And see you next time.